All right, well, we continue to offer you a very thought-provoking training today. So our next guest speakers are going to be presenting on, guardianships, what to know and how to help. Thanks again, Morgan. Greatly appreciate it. So our first speaker, I'm going to kind of flip this around. Our first speaker is a colleague and also a friend. We have had the good fortune of working together with the Office of Public Guardian. Marla Fischer received her Juris Doctor from the University of Nebraska College of Law in 2004. She is currently the Deputy Public Guardian for the Nebraska Office of Public Guardian. Prior to coming to the Office of Public Guardian, Marla served as an Assistant Ombudsman with the Nebraska Office of Public Counsel, where she addressed concerns of Nebraskans who experience individual and systemic difficulties with programs administered by the Nebraska Department of Health and Human Services. Before Marla was with the Office of Public Counsel, she was the Executive Director for ARC of Nebraska for 5 years. In this position, she provided support to 13 local ARC chapters across Nebraska. In that role, she provided advocacy in written and verbal testimony on proposed legislation within the Nebraska unicameral in collaboration with other disability organizations, and she also provided information and ideas on problem solving and action on statewide issues affecting the lives of people with developmental disabilities. In 2012, Marla joined the Nebraska Supreme Court Commission on Guardianship and Conservatorship. Marla was also the public information attorney with Disability Rights Nebraska for 4 years, where she gained experience in developing informational material for people with disabilities, family members, and interested citizens. In addition to her professional involvement, Marla has family members who experience disabilities and currently serves as a private guardian for her sister. And then joining Marla for this next presentation will be Judge Holly Parsley, who was appointed by Governor Dave Heidemann as a county court judge for Lancaster County in 2014. She received a bachelor's degree from Doane University and a law degree from the University of Nebraska College of Law. She was previously employed as an associate in a small law firm in Crete, Nebraska. The firm handled general legal matters, and she then served as a public defender for Saline, Thayer, Clay, and Gage counties. Subsequently, she began her career as a prosecutor with the Lancaster County Attorney's Office in 1998. In that capacity, she prosecuted cases such as domestic violence, sexual assault, white-collar crime, vulnerable adult abuse, illegal drugs, gang violence, robbery, and homicide, and was a prosecutor in the same office for over 16 years. In addition to being a Lancaster County Court judge, she currently serves as co-chair of the Supreme Court Commission on Guardianships and Conservatorships. So please join me in welcoming Marla and Judge Parsley. So Marla. Thank you. It is ready to go. Thank you.
Right, well, I'm definitely glad to be here and talk about guardianship. I know I have just kind of a limited amount of time, so if there are any questions, I'm glad to answer those if time allows during the presentation. And if not, I will certainly try to field those afterwards if those are forwarded on to me. So my presentation it addresses whether guardianship is the answer. And so we're going to take a look at guardianship and kind of considerations for that, as well as other options alternative to guardianship. So what is guardianship? In Nebraska, guardianship protects the person, and some other states use the term conservatorship or both, but in Nebraska it's just for the person. There are 10 statutory areas in which a court might appoint a guardian to make decisions for another person, and the person under guardianship in Nebraska is called a board. So some of those areas of decision, well, all of the areas of decision making, one is selecting where the person lives, their residence, arranging for medical care, protecting personal effects, so their belongings, giving necessary consents, approvals, or releases, arranging for training, education, or other appropriate services, applying for private or governmental benefits, ensuring that the person has the required helps and supports that they need, entering into contracts if there's no conservator, and receiving money or other items of value and applying funds to their expenses, and then any other area that a person might need decision-making help with in terms of their person. So something to know is why people look to guardianship. And so these are just some of the reasons why people consider guardianship. Maybe a person with mental illness is having difficulty making decisions or choices. A person might experience cognitive or decision-making challenges due to aging or illness. Maybe there's a vulnerable adult who's in danger of being exploited, which we heard a lot about today. Medical providers might need to provide care to a person who potentially doesn't have the ability to provide informed consent. And just speaking from the Office of Public Guardian perspective, that is a situation we find ourselves in quite a bit, and being nominated by hospitals to assist in decision making for people. So what should be considered when you're looking at guardianship or other alternatives? In particular with guardianship is to ask whether guardianship will achieve the desired outcome, and then to understand that it's not a quick fix. So for example, if somebody is having difficulty getting the kinds of services that they need, it kind of leads to the next slide or next square, which is guardianship is not a magic wand. Guardianship doesn't create services that don't exist. Guardianship is in place to make decisions for people who are presented with different services or different things that they need to make decisions about. So, you know, while a guardian might help advocate for someone to get the services they need, they can't create them out of thin air. They can just make decisions. A guardianship doesn't necessarily prevent a person from making poor decisions. I have heard, especially in the field of developmental disability, parents had been encouraged to get guardianships over their children who are going to be turning 19 for the fear that they're going to enter contracts or buy cars and things and kind of blow their lives up without a guardian. So, however, I will tell you from experience with the Office of Public Guardian that we're not with people every single day, and we can't physically be there for every decision that they make. And so sometimes people under guardianship will make decisions that are contrary to their best interest, even though we would have decided otherwise for them. And if, in the example of buying a car, a person selling a car to them may not know that they are under guardianship and don't have that ability. So it's a good way to think about protecting someone, but it doesn't necessarily prevent all of the things that you would like it to. And a guardianship takes away an individual's basic rights to make decisions about their life and learn from the choices that they make. And I guess that kind of depends on the person under guardianship as well as the guardian. If a guardian uses something called supported decision making, which I'll go into later, that actually would help provide the opportunity for the board to understand about how decisions are made because they're participating in the process. And then they could, in turn, build capacity to make decisions for themselves potentially later on. So it kind of runs the spectrum, but ordinarily, if a guardian doesn't know that, a guardian essentially makes decisions, and that's kind of the end of things. Something else to be considered is how will having a guardian address each specific need you desire to protect. So again, with alternatives to guardianship, there might be something less restrictive that could be considered to address the need that the person has. And the freedom to make decisions play an important role in defining a person as a human being and determining their quality of life. So you can imagine that losing control of being able to make decisions for your everyday life or the kinds of services that you receive can be very frustrating for people, especially if, let's say, someone has been living independently and really needs a higher level of care, realizing that somebody else now is going to come in and let's say you're in the hospital and you need a higher level of care and you're not going to be able to return home. The guardian ultimately would have that authority to decide where you live, and that can be very, very difficult for a person. Other things that can be considered are determining what alternatives best serve and support and protect the person, and recognizing that those are complex. Since guardianship involves the loss of fundamental rights, it should be considered only when a person can't make informed decisions on their own, or can't be accommodated or supported in decision-making in any other manner. Something else that's important to know is that family members don't need to become guardians in order to stay involved in the person's life. And guardianship doesn't directly address the basic support needs of an individual, and only provides a legal means for someone to make decisions for a person who's been determined that they aren't able to make those decisions on their own. So a guardian doesn't provide direct supports to the person. The guardian provides decision-making for the supports that are needed. So I mentioned that we should look at other options or alternatives, and these are many of the other options that can be considered, and I've listed them in order, left to right, top to bottom, of least to most restrictive. And so the first that I mentioned that I will again go into in a bit is supported decision making. Other options would be advanced directives, kind of letting people know what you want in terms of, say, a living will, or letting people know what you would prefer your code status to be: do not resuscitate, do not intubate, different things like that. Having a representative payee, let's say you only receive Social Security benefits for your income, and you have very few bills to pay, or they're all paid through those benefits. This would be a much less restrictive way to go about getting financial help than having a guardian in place. Having a protective payee, that's similar, however it deals with state benefits, so things like AABD funds and things like that. Similar is the Veterans Administration fiduciary. Again, that deals specifically though with veterans funds. Other considerations could be a healthcare power of attorney, where you would name someone in a document that relates specifically to healthcare decisions, and you would name someone to make those for you. More broadly would be a power of attorney or durable power of attorney, which would encompass more decisions than just healthcare, but the same concept. And then more restrictive is conservatorship. In Nebraska, conservatorship deals with property and contracting. And then limited guardianship, which I mentioned those 10 areas of decision making that guardianship includes. A limited guardianship would only include some of those as were necessary for the person. But then the most restrictive would be full guardianship and or conservatorship. And sometimes full guardianship is awarded if a person really doesn't have much in the way of financial assets. Let's say they just get SSI, supplemental security income or something, then maybe a conservatorship wouldn't be necessary, so a guardian could take control and help manage those finances. So how do you know what the best option is? First, maybe look at the list of considerations and think about how much control you want to have in your life. If you can't make decisions, who do you trust to make decisions as you would have if you could have? I think most of us would say we would like a lot of control in our own lives and how decisions are made for us. So while we're able to do those things, we really need to think about who we know cares about us, who we trust to make those decisions, who knows us best, and who can make decisions for us if that time should come in the event that we can't. You also need to look at what your finances look like, and how you want to plan for those. And who, if you are asking someone else to manage those finances, again, who can you trust, who will understand what your plan is for that and follow what you have planned. And then what services or supports would you want or need in the future? Are you a person who wants to remain in their home no matter what and have services come to you, or are you okay with going to an assisted living facility or a nursing facility as your needs might require? So all of that to say that the very best option is to have a plan. So why should you make a plan? One reason is that the term is interesting. It's called the senior tsunami, and it's coming to Nebraska. And what that means is that Nebraskans who are ages 65 and over is projected to increase from 15%, as it was in 2010, to 24% of the population by 2030. And seniors proportionally experience more disability than the younger population at 35% compared to about 11% of the younger population. Again, why should you make a plan? Because we are living much longer, we're living lonelier, we're more likely to experience disability, and we're more likely to be vulnerable as we age. And I guess the lonelier piece is what sticks out to me in terms of, especially with the pandemic, and thinking about people who have been, they're in care facilities, but they had to be quarantined a number of times and were very isolated over the course of 2 years, and kind of continue to be as people in their facilities come down with COVID and they get stuck back in their rooms again. And so that maybe wasn't such a consideration in the past, or at least so blatantly obviously for people when they were thinking about whether or not a facility would be something that they would want in their life later if they needed that level of care, but it sure is now. So if that's something someone wouldn't want, a plan would be a good thing to have in place and to communicate with someone so that you don't end up there if at all possible. I mentioned supported decision making a few times, and that is just a flashy term for doing what everybody does on a daily basis, which is looking to other people to get information about decisions that we are trying to make. So we're not experts in all areas of things that we need to know, and so we consult family and friends and other people we know, other professionals, in order to make decisions for ourselves. It's supported decision making is kind of an international movement actually, and it's picking up momentum within the U.S. and in Nebraska as well. Some states are actually formalizing it into legislation, and it's kind of and it looks different in different states, but creating supported decision making plans, which sort of look like powers of attorney in a way, but are more formalized things that show who is going to help a person with making decisions, but it's still under the supported decision-making plan. Ultimately, the person who is making the decision, it just says who is going to help them with those types of decisions. So the supported decision-making and guardianship is actually an active link to some publications that the Nebraska group is working on, and I'm part of the steering committee and task force that is being spearheaded by Disability Rights Nebraska, and this particular site goes through the Monroe-Meyer site. So the information there kind of provides more information about what supported decision making is and how to make it work. I believe some of the documents might be more in the context of people with developmental disabilities, but again, it's much more broadly applied and something we all do every day. Another resource is for Missouri guardianship, but it applies here in terms of things to consider, called Understanding Your Options and Alternatives, and it's a resource guide that helps people think about balance, helps them balance support and protection for what they might need. It helps them identify and access alternatives to guardianship within that. And then finally, if you're an attorney, one thing that might be helpful is a practical tool for lawyers, steps in supporting decision making, and it's a resource that's jointly produced by the Commission on Law and Aging, the Commission on Disability Rights, the section on Civil Rights and Social Justice, and the section on Real Property, Trust, and Estate Law. How can you start to make a plan? Well, there are a number of resources, and again, there are other professionals that you might want to consult as well to make a plan. So, we talked about powers of attorney, or different kinds of documents, and so you might want to go to an attorney to create some of those if you want to be very sure about what it is that you're putting in writing. But these are some other ways that you can create things on your own that will help provide guidance to people to exercise what you would want. So the Nebraska State Unit on Aging has many helpful guides and brochures, and so this is a link to that. And so some of the things that you can find there are advanced directives, there's a care management brochure, a living will declaration, there's a guide on managing someone else's money, there's a power of attorney form and a healthcare power of attorney form, just to name a few. And then there are also some helpful tools on the American Bar Association site, such as 5 safeguards to consider adding to any power of attorney for finances. That offers tips to include in a power of attorney for finances to prevent misuse of powers, as well as a document on healthcare decision making, which has resources such as a healthcare advanced planning packet, consumer information videos, and then other resources for attorneys. So of course, we all know that the best laid plans may not pan out. So what do you do if your plan fails? So recognize that, first of all, it's important to make the plan, and that's first and foremost. But if your best efforts to make a plan fail, it could be because sometimes a person might act outside their scope of authority. So if, let's say you have a power of attorney document and somebody is acting under that, they could, and some people have, exploited people. Some people believe that their power is more broadly, or kind of throw themselves around as if their power is more broadly under that document, and might potentially financially exploit someone, even though they either don't have the authority to manage someone's finances, or they do but are simply misusing the funds. And in some of these cases, then guardianship really is the answer, but I would keep these things in mind, that it should only be pursued when the person is unable to participate in decision making in a meaningful way, and urgent decisions have to be made to protect their person or property. And no one has the legal authority to make those decisions, or when the person is unable to protect themselves from harm and there's nothing else available, then guardianship might be something to look at. And the last thing, if you don't make a plan, others will do it for you, but you might not like it. You have a risk for loss of autonomy, and there's a greater risk for guardianship, but what if there's no one to act as guardian? And again, I refer back to the senior tsunami, so that is something to think about. The bottom line is to be aware of your wants and needs for the future, how you want those carried out and by whom. Again, the senior tsunami, and then consider guardianship might be necessary, but should always be the last resort. And that is all.
Thank you.
Thank you.
All right, then. Marla, thank you. Terrific presentation. All right, and Judge Parsley, Morgan will help us get everything set up. She's done a grand job, so thank you, everyone. All right, very good.
All right, ready to
Thank
go?
you. There you are. Thank you. Thank you.
Thank you. Good afternoon, and thank you for giving me the opportunity to spend this time with you today. There's a lot of stuff that I could talk about, so I've tried to pare it down as much as I can, but I probably will talk fast because there's a lot to cover. So, first of all, guardianships, what to know is kind of where I'm at today. So we're just talking about the very basic things, bare bones. There are 2 types of guardianship cases in Nebraska. We have guardianships for minors, and we also have guardianships for adults. When we're talking about minors, the issues that we're dealing with are for children whose parents are either unfit or have abandoned their minor child. Also, this includes unaccompanied minors from outside the United States that come to the United States, and they don't have a parent because their parent is in another country, and they need someone to make decisions for them and care for them. Regarding adults, this includes developmentally disabled adults, also includes adults with an event-provoking incapacity, like a traumatic brain injury after an accident or something along those lines, and adults with compromised cognitive abilities, more related to sort of senior more senior, dementia, Alzheimer's, that kind of thing. So in Lancaster County, because I can only speak about cases in Lancaster County, that's what my purview is, I have about 1,500 open cases. And that number is only the cases that have already been established that I'm monitoring on an annual basis. So, and regarding minors for Lancaster County Court, this is going to be separate from juvenile court. So take off your juvenile court hat if you have that on, because this really is not people that are involved in the system or anything like that. This is minors who have someone step forward, a lot of times a grandparent or something like that. So those are 25% of my cases, and those will end someday, if not before the child turns 19, certainly by the time when the child turns 19, jurisdiction of the guardian is done and they have no more authority. So those cases are finite. They're about 25% of my caseload. 75% of the guardianships that I have open are for incapacitated adults. There's a major difference in those because they're not finite. They include folks who were developmentally disabled and at age 19 got a guardian, but they're now in their 50s or older than that. And as Marla referred to, the silver tsunami or the senior tsunami, I guess, either way, that's coming. So we think about that. I want to talk to you just a little bit and touch on the most litigated guardian cases that I have. And these are going to be just related to our adults. I'm not going to refer anymore to the minor cases because that's not the subject of the presentation today. So focusing on incapacitated, I have a lot of cases that we litigate or have a trial when the incapacitated person or alleged incapacitated person does not want to be incapacitated. So first and foremost, I have to make a decision whether or not the subject of the petition is actually incapacitated. And I will absolutely 100% always give the person who's alleged to be incapacitated their full day in court to say what they want to say about whether or not they're incapacitated and present any evidence that they want. Sometimes they just want to say something brief and just let me know that they don't like their situation or something like that, but we'll have a trial and sort of try to weed through some of that. So that's my first, and then we have children, adult children, that are sort of versus each other. So we have siblings that don't get along, and now mom is elderly, can't make decisions for herself anymore for whatever reason. Either there was a power of attorney, but something has happened and that went wrong, and or there isn't one, and somebody's got to be the decision maker. So now we have adult siblings who maybe never got along, honestly, fighting against each other about who should get to make decisions for mom. Sometimes in the sad cases too, I do have siblings who have got along all their lives, and now for some reason there's been a falling out and they don't see things the same way. Finally, I have the adult children against the spouse of the incapacitated person, who is someone who maybe they married later in life and is not the mother or father of the children of the incapacitated person. So there's a bit of a tug of war there between those two categories. So those are my most litigated guardianship cases for an incapacitated person. I want to touch just briefly on the process of appointing a guardian. First of all, if there's an immediate need, I can issue a temporary guardianship, which is ex parte, which means that the alleged incapacitated person doesn't even get served with that before I go in and appoint someone because there's an emergency. That lapses in 90 days. After the temporary, sometimes at the same time, if you know that the nature of the incapacity is going to be permanent, then the permanent petition is also filed. Now, this one doesn't lapse when it's granted. It is terminated only upon termination by the court. So the questions that we ask, and I don't want to mirror, I guess, Marla's presentation or overlap, but we have to ask ourselves as the court, is this the least restrictive alternative? There's sometimes that there is a power of attorney in place or a healthcare power of attorney, and I have said, no, I'm not going to, this isn't the least restrictive alternative. The person who is incapacitated made a decision when they had their faculties that this is who they wanted to serve as their power of attorney or healthcare power of attorney, and this is what they wanted their powers to be. There's no reason for me to second guess that unless there is a reason, like the power of attorney is a bad person and they shouldn't be in charge of them. So is it the least restrictive alternative? Again, talk about all the things that Marla addressed in alternate ways to handle the situation. Then I have to decide, not necessarily in this order, is there clear and convincing evidence of incapacity? And I talked about that a little bit. So I have to find by clear and convincing evidence that there is an incapacity. Once I do that, I have to make a decision whether this guardianship should be full powers or restricted or limited powers of guardianship. So maybe maybe they can't handle contracts or things like that, but they can decide where they can live. So I might limit it because there are certain things that they're able to do. Sometimes the alleged incapacitated person and the petitioner, the person who wants to be the guardian, sometimes they come to an agreement too. Like, okay, well, I'll let you make these decisions, but I won't let you make those. Or maybe I decide, well, this person can do everything except for they're really scared and they don't make rational decisions when it comes to maybe needing surgery on something. I've had that happen before, where it could be a life-threatening situation. And so I have to determine what that is. And then also, in the same thing, I have to decide whether a nominee is appropriate to serve. And when I say that, a lot of times they are. Most times they are, but I've had situations, in fact I had one this morning, where the two nominees are both listed on the Adult Protective Services Registry as either, I can't remember if it's agency substantiated or court substantiated, but then they're also listed on the Child Abuse Registry as whatever the other one is. And so I was kind of like, I can't think of a time that I've appointed somebody that's listed on the registry. So that's what I have to do. I have to give the bad news. Once there's an appointment decision made, there are forms that are needed after appointment. When I do an appointment, I walk you through those forms. The attorneys also are very good about that. And then finally, on an annual basis, reports are required to be submitted to the court and also mailed to other interested parties. So if you have that situation where it's siblings, I had to choose one of the siblings to serve as the guardian, then they have to send a copy of the annual report to the others, just to make sure we're keeping everybody in the loop. Not only that, but my main concern is the incapacitated person, and so I want to make sure that everyone has access to the incapacitated person and has access to the information that should be available so that they can decide, is this being handled appropriately? So that's kind of what we do there. Again, Marla had a slide similar to this, and I'm not going to go through this because you can read it for yourself. But the statute, these are the 9 areas that I can appoint. We do have a limited guardianship form where I can check the box and say, okay, the ward or the guardian can do number 3, 5, and 7, or whatever it is. And so I have to make that determination. And if it's a limited guardianship, I check the appropriate box, and then when I do the letters, they should mirror that as well. We will come back to court if needed, if that needs to be updated, and sometimes it does. I've had cases both ways. I've had cases where they come back in and things have gone downhill, so they need a full guardianship. On the other hand, I've had things improve, and that's my favorite time, is when things improve, and then I can take away some of these things and balance it out a little bit more appropriately. So that's always something that we keep under review, which is also why we have the annual report, so I can take a look. More statistics in Lancaster County. 80% of the guardians serving right now in Lancaster County are a family member. I keep track of this because it's important to me, because I can quickly look at who is serving, and sometimes it gives me a better reference as far as if I see something a little bit off, maybe in the spending, whether I should be concerned or not. In my experience, I have found that a parent serving for their adult incapacitated child will rarely, number one, have much money to steal, but number two, will rarely be taking advantage of their own child. In fact, I've found quite the opposite. They're spending their own money to make sure that their adult child is comfortable and has the things that they want. So those things make a difference to me, which is why I sort of keep track. Also, you can see that the other numbers are much smaller, and I've categorized those as friends, family friends. I do have some attorneys that serve. I have some professional guardians that are guardians for more than one person, but they're unrelated. And then I do have the Office of Public Guardian. I told you these cases aren't finite. My guardianship, that is the oldest, I believe, right now, was appointed in 1975. So if you can picture that in terms of, you know, your age maybe, and how long that person has been serving as guardian, and that is the same person that's been serving as guardian since 1975. It's a lot to ask of someone to do. 1976, I have 3, so I have, and then it goes from there. But I just wanted to give you an idea of when I say these aren't finite, they can last a really long time. In Lancaster County, the Office of Public Guardian is currently serving 47, and I do have 10 people on the wait list for the Office of Public Guardian. There is one that has been pending since February of 2021 that we just haven't been able to clear up yet. So I've still got people, and it's going to get worse because of the tsunami that's coming. So, frontline issues regarding the incapacitated adults. So this is just kind of the nutshell version. What I'm most concerned in is protecting the ward's rights, and also I will reveal to you, if you haven't already figured it out, what the most urgent concern is from my perspective. All right, first of all, protecting the ward's rights and due process. If I talk really fast, it's because I know my time is limited and I want to give you a chance for questions. So the next few slides, I pared this down from another presentation that I did where I was able to go a little more in depth and show interesting video clips. But on this one, I'm just going to kind of give you a picture so you can look it up later if you want and be like, oh yeah, that was really something I was interested in. Everybody knows who this is. This is Britney Spears. In California, like Marla alluded to in other states, a conservatorship is the same thing as what we call guardianship here, and that's a very simple explanation. But there's been a lot of talk about Britney Spears and the Free Britney movement, and this has sort of helped, I think, get more national attention to the issue of guardianships and conservatorships and exactly what the problems can be with them and why it's important to us, because you don't really want somebody who can has the ability and the capacity to make as much money as she does and function on the level that she functions, being under a full, you know, authority situation. She might have had some issues a while ago, and again, like I told you, I reviewed those, and this is a case, in my opinion, that should have been, you know, if it was limited at all, if it wasn't limited at first, they should have just progressed as she began to show signs of improvement. No more comment on that. I think everybody sort of gets it there, but I kind of am grateful for the situation to bringing that to the attention of the nation and even the legislature. This guy, Doug Keegan, if you have a chance, look at this, because there's some really interesting stuff on YouTube about this guy. He was under a guardianship in Florida because he married, brought somebody over from another country to marry her, and his relatives were really upset by that, thought that he wasn't making good decisions. I think that at least that's how this situation began. And then at some point, I mean, the guy is living independently in his own, actually in a hotel, but it was more like a long-term, more like an apartment. And he talks about, you know, I've got paper, you know, I have everything on my refrigerator, I know my appointments, I know this, I know that. And also, I think there was, I should correct myself, go back, there might have been a bit of an alcohol problem at the beginning of this too. But regardless, finally they got it dissolved in, I believe, May of 2021, but it took him a while. He's very articulate, he's kind of interesting to listen to. So this one is stunning. This person, April Parks, was a guardian or conservator for 150 people, I believe. There is a movie on Netflix, I don't know if it's, I watched it a little while ago, but it's called I Care a Lot. And believe me, if you ask her, she cared a lot, because she cared a lot about the money coming in. In fact, she attributed a charge for $108 for stretch pants for an elderly woman. Well, I don't know any elderly woman that would pay $108 for a pair of stretch pants, but these people got taken, lots of money taken from them, and it's very sad. This is just a snapshot of the prosecutors in her, criminal case where she got prison, thank goodness. This is just a snapshot of some of the faces of the 150 victims that she bilked out of hundreds of thousands of dollars. Again, another thing that I'm glad received some national attention, because we want to watch out for this and we want to try to protect these people. Finally, I love Rudy and Rennie North. This is a Nevada case, and they're senior citizens that were appointed a guardian, and there's a documentary and the documentary channel called The Guardians. It's again, if you YouTube them, you'll find some stuff, but their daughter, I think it was, she was just beside herself because she couldn't have access to them, and it was a very sad situation. So, due process. That's why I want to focus on due process a lot. I'm very concerned about how the ward wants to, what decisions they want to make, and whether or not somebody's taking advantage of them. I don't want them to just feel like they don't have access to the court, or they don't have any decision-making ability in their world, because that's very important to them, as it should be. And we should respect that, and if a guardian is not respecting that, I remove them without any questions, really. So, guardian shortage is our most urgent concern, and the reason why is because we do have the aging population concern. Right now, we have a guardian shortage, just like as we sit here this moment. I think I told you I have 10 on the waiting list for Office of Public Guardian. I have more out there that haven't applied to the waiting list yet, or something, or we just had to. Actually, some of them have died while they're waiting for somebody, but. We really need guardians. So if you are out there listening and you feel like you have a little extra time, I know that this court would be always appreciative and very sort of helpful to you if you were interested in taking on that role. I do have some people that are just very good citizens, and they want to help out, and they have volunteered to do that, and they are still serving. So, our doors are always kind of open. But we care about these cases. We care about our aging population. It's going to explode, or maybe gradually explode. It's just getting bigger. So thank you for listening to me today. And this is a website that is something I created a few years back. It just gives you a little bit of information about guardianships, and it's also what I use for the guardians I appoint to sort of link them to the forms that they need and the annual reports and some information like that. So again, thank you for attending today, and are there any questions?
Yes, we have some rapid fire questions if you want. I think there may be for Tressa.
Sure. Yeah, coming up.
Okay, I'll just go ahead, and I think there's a few questions in here, and just kind of rapidly spin them off here. First one was, what would your recommendation be for a drug addict or alcoholic for guardianship?
I have no idea. I don't know that it totally depends on what the person's situation is. Honestly, in our experience, when we have people who experience addiction, a lot of it is kind of a lack of services available for them, and I'm not sure that, again, a guardian doesn't have a magic wand, but even a less restrictive option would also be very difficult to help the person. So it's just a very difficult situation.
Do guardians or durable POA ever get paid for being in this role?
Guardians can sometimes be paid. Judge Parsley, do you ever?
Yeah, they can. It just, again, it depends. It's kind of one of those things that I review. If the guardian is going to pay themselves, they have to have my permission to do it. So I have to make sure that it's reasonable for them to be paid, and frankly, a lot of folks that we see don't have a lot of extra money. Some of them do, but a lot of them don't, and so it might be a nominal fee. Sometimes I just grant a standing order of, $40 a month as a fee or something like that. But I always tell people, if it's something they want to do to try to get rich, it's not the place to look.
If there is a power of attorney invoked, is there ever a need to pursue guardianship?
Again, that depends. It depends on how the power of attorney is being carried out, or if the person named under the power of attorney to act as the agent for the person wants to continue in that role. I know sometimes we've become guardian for people because the person who's been named as the agent can no longer do that, or they've passed away and no one else has been named, or there's just different situations that go on that create the need for a guardianship, so it depends.
I'm gonna weigh in here for just a second. I've had cases where just recently, lots of litigation on a case where 3 siblings were appointed as the power of attorney, but 2, they didn't agree with each other on how to treat mom. 2 were ready to not treat anything and let her go, and 1 wanted to treat everything, and so we had to litigate it, and I had to decide of the 3 who were all qualified and who mom named, which one I should appoint. So yes, it sometimes comes to me, unfortunately.
Can people who have guardians vote in local, state, and national elections?
Yes, Nebraska doesn't have anything that restricts people's right to vote, even though they're under guardianship.
This is a question for Judge Parsley. You mentioned incapacitated being developmentally disabled, TBI, cognitive abilities. What is your viewpoints on capacity in those with mental illness who are not seeking treatment? This can include addiction.
Okay, so ask that last part of the question again.
The last part was basically what are your viewpoints on capacity in those with mental illness who are not seeking treatment? Can this include addiction?
Okay, yes, it can. I have several cases where I have somebody that has a definite mental illness that won't seek treatment, and it's frustrating, it's hard. I have appointed guardians in those cases, and sometimes you're kind of setting them up for failure because they're trying to get mom, in this case, into treatment, and she won't go, and it's just an ongoing thing. Sometimes, unfortunately, like Marla has said more than once, it's not a magic wand. You can't make them and force them to, do things that they won't.
Okay, and last question. What happens if the guardian passes away? There is another person willing to fill this duty, but until this happens, does that mean the person is again their own guardian, or what is the best process for this?
Best process is to contact an attorney immediately and get a temporary, like I talked about, the one that lapses in 90 days, just to get that covered, and then go through the process of appointing a successor. There are several people out there, like I mentioned, the ones that don't have guardians right now, that are kind of just their own guardian until somebody's appointed. But my recommendation, call a lawyer, get that petition on file, I'll sign it, we'll get them squared away so there's no gap.
All right, very good. Well, thank you both very much.
Thank you.
A very powerful presentation to get both sides of the story. All right, we are going to take a short break, and we will return at 3 o'clock, and then we have 2 just terrific presenters to close out the day. Dr. Josie Schaefer, who will be presenting on the future of aging in Nebraska, and then Ryan Sothan, who will be presenting on Nebraska scams and anti-fraud education, and he always delivers a wonderful presentation. So enjoy your break, and we'll see you shortly. Thank you.